Welcome to the deep dive. We're here to cut through the noise and really focus on the insights that matter to you.
Glad to be diving in.
Today, we're tackling something huge, something that really hits home if you're involved with property in India. Buying, selling, even just thinking about it.
That's right. There's been a very significant ruling from the Supreme Court of India. It actually just dropped today, June 13th, 2025.
And it introduces a deadline, a hard deadline you absolutely need to know about.
It's not just some abstract legal point. This is a real-world game changer. It affects things on the ground right now.
Okay, so our mission today, our deep dive goal, is pretty clear. We need to break down exactly what this ruling says. Why did the court make this move? What happens, and this is the crucial part, what happens if you miss this new deadline?
And most importantly, what practical steps can you, the listener, take to protect yourself, to protect your investment? Because this ruling, effective today, June 13th, it's already reshaping things.
Think of this as your essential guide to navigating this new landscape.
Exactly. Your roadmap.
All right, let's get into the core of it then. The Supreme Court. A major mandate about property sale deeds. What's the headline?
The absolute heart of it is this. Any property sale deed has to be registered. No ifs, ands, or buts. Registered under the Registration Act of 1908.
Okay, registration. That's standard, right?
Yes, but here's the kicker. There's now a very strict time limit. You have exactly 4 months to get that registration done. 4 months from the date the signing starts.
4 months. That feels tight. What if you don't make it? What if that window closes?
Well, the court couldn't have been clearer. Missed that deadline, and the deed is legally worthless. Invalid. Null and void.
Null and void. So it's like the deal never legally happened.
Pretty much. Imagine, signing a huge business deal, but forgetting the final step, the official filing. That contract, it's just paper. No legal teeth. Same idea here.
Wow. So this 4-month clock, it's not just a suggestion, it's the law enforced now.
Absolutely.
Yeah.
They come straight from Section 23 of the Registration Act itself. That's the part of the law that says documents like sale deeds must be presented for registration within 4 months of execution when they're signed.
Okay, execution meaning signing. Now, property deals often have, multiple people involved, sellers, buyers. What if they sign on different days? When does that 4-month clock actually start ticking?
Good question. That's a really important detail, and Section 24 of the Act covers it. If you have different parties signing at different times, the 4-month countdown for registering that whole document starts from the date of each signature individually.
So wait, how does that work practically?
It means the deed needs to be presented within 4 months of the last required signature being put on it. So if buyer 1 signs today and seller 2 signs in a week, you need to get it registered within 4 months of that second signature date. Needs careful coordination.
Right. Got it. Okay, this is where I get really curious. Why 4 months? And why is the Supreme Court emphasizing this now? What's the backstory here?
Well, the 4-month period itself isn't new. It's been sitting there in the Registration Act for, over a century. What the court did today was basically shine a massive spotlight on it, enforcing a rule that, frankly, a lot of people either didn't know about or were maybe conveniently ignoring.
So the timing wasn't arbitrary.
No, the 4 months is meant to be a balance. Enough time to sort out the paperwork, get the stamp duty paid, navigate the registrar's office, which, let's be honest, can take time, but not so long that deals are just left hanging indefinitely.
Right. Prevents things being stuck in limbo, creates certainty.
Exactly. Unregistered deals create huge uncertainty. They're breeding grounds for disputes later on. The specific case that prompted this ruling really highlighted a super common problem across India. People delaying property registration, sometimes for years.
Why? Why were people delaying? Just forgetting or...
Sometimes, yes. Genuine lack of awareness, maybe just procrastination, simple human error. But often there were other motives, more calculated ones. We see cases where people deliberately delayed registration to kind of game the system, maybe hoping to dodge an expected hike in stamp duty rates. Save some money.
Timing the market, but for taxes.
Sort of. Or sometimes trying to keep the transaction less visible, maybe for tax reasons, trying to fly under the radar.
And the court's basically saying, nope, not anymore.
Loud and clear. That kind of maneuvering isn't okay. And this isn't just a big city tycoon problem either. Unregistered deeds, delayed registrations, it happens everywhere. Urban centers, rural villages. Sometimes it's lack of knowledge. Sometimes it's trying to exploit loopholes.
Okay, so let's spell out the stakes. If someone misses that 4-month deadline, maybe they signed something last month, maybe they signed something tomorrow, and now this June 13th ruling is, in effect, what actually happens to them? What are the real consequences?
The number one consequence, the one that should frankly keep you up at night if you're in this situation, is your sale deed becomes invalid.
Hmm.
Legally, based on that document, you do not own the property.
That sounds terrifying, especially if money has already changed hands.
It can be absolutely devastating. The risks are huge. Think about it. Without a valid registered deed, what stops the seller from just turning around and selling the same property to someone else?
Nothing legally, I suppose.
Exactly. You'd have no solid proof of your claim recognized by law. You could lose all the money you paid, maybe your life savings. And then you're looking at a long, expensive, stressful legal fight with no guarantee you'll win.
Beyond losing the property itself, what about other financial hits?
Oh, absolutely. Stamp duty and registration fees. These aren't optional. They're required government charges that make the transaction official. Stamp duty alone is a big chunk of change.
How much are we talking?
Varies by state, but often somewhere between 5% and 7% of the property's market value. So think maybe 6% in Maharashtra, around 7% in Tamil Nadu, plus the registration fees on top.
Okay, so if your first deed gets invalidated because you missed the deadline.
You'll likely need to execute a new deed and register that one, assuming the seller cooperates, which means
Paying that 5-7% stamp duty all over again.
very likely, yes.
Yeah.
And here's another painful twist. Property values usually go up over time. So the market value might be higher when you execute the second deed, meaning your stamp duty bill will be even bigger the second time around. A very expensive mistake.
And what about using the property? If the deed's invalid, can you get a loan against it? Can you sell it later?
Nope. A property you don't legally own via a registered deed is effectively frozen asset-wise. Banks won't give you a loan against it. You definitely can't legally sell it on to someone else. Plus, an unregistered transaction can wave massive red flags for the tax authorities.
Yes.
It can look suspicious. They might start asking questions about tax evasion or where the money came from. It just opens up a whole can of worms.
So the bottom line is trying to delay registration, whether intentionally or just through oversight, isn't just risky. It's like playing financial Russian roulette.
That's a very good way to put it. An incredibly precarious position.
Yeah. Is there any way out, like a second chance? If you accidentally miss that initial 4-month window, is it game over completely?
There is one potential lifeline, but it's not automatic, and it comes with conditions. It's called condonation of delay, provided under Section 34 of the Registration Act.
Condonation. Like asking for forgiveness for being late.
Essentially, yes. You can apply to the registrar, asking them to excuse the delay in presenting the document. You have an additional 4 months after the first 4 months have expired to make this application.
Okay, so a total possible window of 8 months. But that second 4-month period needs a special application and approval.
Correct. And here's the catch. You need a good and sufficient cause for the delay. You have to convince the registrar that there was a genuine, legitimate reason you couldn't register within the first 4 months.
What counts as a good reason? I forgot. Probably doesn't cut it.
Definitely not. Nor does I was busy or I was trying to save money. It needs to be something substantial, something that genuinely prevented you. Maybe a serious illness, a natural disaster affecting access, that sort of thing. It's up to the registrar's discretion.
And if they do accept your reason, is there a penalty?
Yes, there's a fine. And it can be hefty, potentially up to 10 times the original registration fee, depending on the state rules. So even if you get the delay condoned, it's going to cost you.
Did the Supreme Court mention this condonation clause in their ruling?
They did. They emphasized that Section 34 is not meant to be an easy escape hatch for negligence or deliberate delay. The court wants registrars to scrutinize the reasons very carefully. The whole point of the main ruling is to enforce discipline, not to provide a convenient workaround.
Let's make this really concrete. You mentioned real people are affected. Tell us about Ramesh's story.
Right, Ramesh. He's a regular middle-class guy in Lucknow, saved up for years, bought a small plot, signed the deed back in January 2025, paid the seller, thought everything was fine.
But he didn't know about the deadline.
Exactly. He was unaware of the 4-month rule. By the time June rolled around, his deadline had passed. He went to register and boom, told his deed was invalid.
Oh no. What happened then?
The seller, realizing Ramesh's deed had no legal standing, just sold the same plot to someone else. So Ramesh is now out of pocket, no land, and facing a horrible legal battle, trying to maybe get his money back. A nightmare.
And Priya in Bengaluru, her situation was different.
Yes, Priya was an investor. She knew about registration but deliberately delayed it. She was trying to time the market, maybe wait out a rumored stamp duty increase. Thought she was being smart, saving money.
Until this ruling hit.
Precisely. The June 13th ruling came down, her window had closed, her deed was invalid, her attempt to be clever backfired massively. The seller knew she was in a weak position and renegotiated the price upwards. She ended up paying more to secure the property she already thought she owned.
Wow, these examples really drive home the impact, and you're saying these aren't just isolated cases.
Not at all. They represent widespread issues. Unregistered deeds, delayed registrations, they fuel countless property disputes, clogging up the courts, causing immense financial hardship and emotional trauma.
Yeah, I saw some of the reactions online earlier today. People on X calling it a game changer, for sure, but also a lot of frustration about the practicalities.
What were they saying?
Things like, the bureaucratic nightmare of actually getting things done at registration offices, long queues, hard to get appointments, lost files. Someone joked it's harder to get a registration appointment in 4 months than a doctor's.
That really sums up the tension, doesn't it? The court lays down the law, but the system on the ground needs to support people trying to follow it. Those practical challenges are very real.
Let's step back a bit. Why is registration itself now, with this strict deadline, so fundamentally important? Why does it matter so much?
Because registration is basically the foundation of a trustworthy property system. Without it, you have chaos.
How does it prevent chaos?
When you register a deed, it creates an official public record of who owns what. That public record is crucial. It makes fraud much harder, like preventing someone selling the same property twice. It gives the buyer clear, legally recognized proof of their ownership, their title. It settles disputes before they even start, ideally.
It's the official stamp of, this is mine.
Exactly. And in India, where land is so incredibly valuable, both economically and socially, ambiguity over ownership because of unregistered deals leads to disaster. Endless court cases, bitter family feuds, sometimes even violence. This ruling is the court trying to impose order, transparency, and discipline.
Okay, super important context. Now let's get really practical for our listeners, for you listening right now. Based on this ruling from today, June 13th, what are the absolute must-do steps if you're buying or selling property in India?
Okay, step 1, absolutely non-negotiable. Know the clock. The second that sale deed is signed, mark your calendar. 4 months. Set phone reminders, put sticky notes everywhere. Do not lose track of this date.
Don't just assume you'll remember.
Absolutely not. Step 2, hire a good lawyer. Seriously, a competent property lawyer is worth their weight in gold here. They'll guide you, make sure the deed is right, advise on stamp duty, and help you navigate the registration process within that critical 4-month window. Don't try to DIY this to save a few rupees. It's false economy.
Okay, lower up. What's next?
Step 3, budget for stamp duty. Know the rates in your state before you even sign. Have those funds ready. Don't delay registration thinking rates might drop. We saw what happened to Priya. It's a terrible gamble. Remember, it's often 5–7%, could be 6% in Maharashtra, 7% in Tamil Nadu, plus fees. Plan for it.
Got it. Budget sorted. Step 4.
Step 4, get to the registrar's office early, or at least start the process early. We heard the online comments. These places can be jammed. Check if your state has online appointments. Book one ASAP. Get all your documents lined up, deed, IDs, property papers, payment proofs. Be organized. Don't wait until month 3 to start thinking about it.
Good advice. What else?
Step 5, double-check signatures, especially if staggered. If you've got multiple people signing on different dates, remember Section 24. Track those dates meticulously. Make sure the final signed document is ready for registration well within 4 months of the last signature. Your lawyer is key here too.
Makes sense.
Step 6, resist the temptation to delay. Even if you think you see a potential saving down the line, the risk of your entire deal being invalidated is just too high. It outweighs any potential minor gain.
And finally?
Step 7, keep all your receipts. Proof of payments for stamp duty, registration fees, lawyers' fees, everything. Keep meticulous records. You might need them.
And just to reiterate, if the worst happens and you do miss the deadline.
Remember Section 34, the condemnation application. It's there as a last resort within the next 4 months. But you need a very good reason, and you'll pay a hefty fine. The absolute best strategy is avoid needing it all together. Get it done right the first time within the first 4 months.
This ruling definitely adds clarity, but we touched on the system's challenges. It's not always easy for people to comply, right?
No, it's not. We have to acknowledge the practical hurdles. People face long queues, sometimes confusing procedures, maybe unhelpful staff, potential delays finding files, and unfortunately, sometimes touts trying to take advantage of the confusion.
So the law is clear, But the implementation needs work.
Exactly. Legal clarity is one thing. Administrative efficiency is another. There's a real need for ongoing improvements. More digitization, like e-stamping and online appointments everywhere, maybe a unified national portal eventually, better training for registry staff, and clearer public information campaigns, especially in rural areas.
And the ruling itself isn't without criticism.
No, some critics feel the 4-month deadline is just too rigid, especially for people in remote areas with less access to banks, lawyers, or transport. The fines for condonation are also seen by some as overly punitive, almost like a revenue grab.
And what about deals signed before today, June 13th?
That's a big area of uncertainty. The ruling focuses on enforcement moving forward, but it doesn't explicitly say what happens to deeds signed, say, 6 months ago that are still unregistered. It leaves those people in a kind of legal limbo, which is worrying.
Yeah, because you have to think about the human element. You mentioned a farmer in Bihar. Someone like that shouldn't lose their land just because they weren't aware of a complex legal deadline.
Absolutely. There's a tension there. The goal of order and preventing fraud is vital. But the system needs to be fair and accessible. Perhaps future clarifications or government guidelines might address cases of genuine hardship or provide clearer pathways for older, unregistered deeds. It's a balancing act.
Okay, so let's wrap up this deep dive. The big message from the Supreme Court's June 13th, 2025 ruling is stark. It's a major wake-up call.
The message is loud and clear. Register your property sale deed. Do it under the Registration Act, 1908, and do it within 4 months of signing. No excuses.
Because missing that deadline means your deal, your ownership claim based on that deed is invalid, legally gone.
But looking at it positively, this ruling does bring much-needed clarity. It should, over time, reduce disputes, offer better protection for genuine buyers, and push towards a more transparent property market despite those system challenges we discussed.
So the key takeaway for you, listening now, is knowledge and action. Ignorance isn't a defense. Complacency is dangerous. Know this deadline, be proactive, get registered, pay your dues, and make sure your ownership is rock solid.
It really is the only way to safeguard your investment and your peace of mind.
And as a final thought to leave you with, this situation really highlights a fundamental challenge, doesn't it? How do we build legal systems that are strict enough to work to prevent chaos and fraud on a large scale, but are also fair, understandable, and accessible to every single person, no matter their background or where they live?
That's the constant tightrope walk for lawmakers and courts everywhere, finding that balance between necessary rigidity and human reality.